everyone. My capstone is on intellectual property and how it relates to freelance writers and bloggers. I've been interested in intellectual property law for a while now. I came from a science background where patents are more common, and so I naturally sparked an interest in this particular kind of law. I brainstormed a similar idea in Dr. Perbix's research and theory course, but the topic has changed and expanded since then, and I'm really excited to share this with you as it's something that I'm particularly really interested in, and I think it's something that people could learn from. So I'm going to go ahead and get started. So first, a little background on intellectual property. This is very high level, so I don't know that you'll learn anything per se, but it's good information nonetheless. Copyrights are for creative works, trademarks are for brands and products, patents are for inventions, trade secrets are for proprietary information, non-disclosure agreements are to ensure discretion, and non-competition agreements are to limit outside job opportunities. Now, like I said, it's very high level. We'll be going into a little bit more detail as we continue, but the first thing I want to let you know is that we will not be covering patents at all in this presentation or in the paper that I wrote to accompany it. Patents just don't apply to technical communicators, including freelance writers and bloggers. There's just nothing that I could find in any sort of research that relates one to the other. So I just thought it was best to not include it and to focus on the things that I knew would relate. So let's go ahead and start with copyrights. Copyrights are the exclusive right to reproduce, publish, or sell creative works. Obviously that pertains to writing, but it also relates to music and movies and anything creative, really, artwork or anything that could be considered creative. So how copyrights relate to freelance writers? There are two things that freelance writers really have to remember. The first is who owns the copyright. Generally, in most cases, the company or publisher will own the copyright, and the freelancer will probably be asked to sign an agreement upon accepting work that states that the company owns the copyright. And this is a really good thing. It sounds bad because the freelance writer doesn't own their own copyright, but it's a good thing because if something were to go wrong, if there's any sort of legal trouble and any sort of infringement possibility, the company or publisher will go to bat for the writer, and the writer won't have to cover their own legal fees. So it's a good thing. It's an important thing. It's something that is really good for the industry. So then the other important thing to know is how to avoid infringement. So obviously the most important part of this is, always get permission before you use someone else's work. That seems super easy, but it's not always that easy if they're hard to get a hold of or anything like that happens. And then it's also important to be aware of what falls under fair use. Fair use in the cases of copyrights generally refers to something that used to have a copyright and the copyright has since expired, and that is why it's entered the public domain. That's not the only way that things become to fall under fair use, but that's the most common way. So then how do copyrights relate to bloggers? It's very similar to freelance writers, except the blogger always owns their own copyright. That's important just because you're posting yourself, you're doing everything yourself, and therefore it's yours. It's completely yours, and it's yours whether you register it with the Copyright Office or not. I didn't come across anything in research that says that bloggers generally register their own stuff with the Copyright Office, but it's not unheard of. It could happen if it's something that you really want protected and you're worried about it. You can also protect your work to some degree by registering with the Creative Commons, and that will allow you to decide how you want people to be able to use your work, and then you can put the Creative Commons little logo on your website and people will know that they can only use it for these certain things. Again, with bloggers too, it's also important to avoid infringement, and it's actually more important for bloggers because there are so many types of creativity available online that it'd be so easy. It is so easy to violate copyright online. You don't think it is, but it's easy. You can use any picture, any video, anything like that. If you don't have permission from the original owner of the material, you're violating copyright. It's that easy. It is scary how easy it is. And the other interesting thing that I found is that to some, reblogging may be considered copyright infringement. I know WordPress and Tumblr both have that feature. It's very prevalent on Tumblr. It's one of the main features, and that's how people's creativity gets out. So it's interesting that it's becoming a legal issue, that people are thinking that it might be copyright infringement. So they're trying to look out for the creators of this work, but then you also have to think about, oh, well, then how is my work going to get shared on a place like Tumblr if it can't be reblogged? So things to think about. That there haven't been any court cases having to do with that yet, but I wouldn't be surprised if that started to happen in the future. So now, trademarks. A trademark is a mark used to identify ownership of brands, products, and slogans. So trademarks and freelance writers. For the most part, trademarks are fair game. Anyone is allowed to write about a brand or a product, and as long as the freelancer isn't trying to market a product under a trademarked name, they should not run into any trouble with that. The example that I kept using in my head when I was practicing for this was, say you are writing about a Ford F-150. That's fine. It gives Ford a little bit of publicity and you get to talk about your truck. But you can't decide to try to sell a knockoff truck and call it a Ford 150, because then you'd get into big trouble with trademarks. So that's kind of the difference. You can talk about it, but you can't try to make money off of it. And also, it should be noted that sometimes freelancers will be asked to write for a company that does own their own trademarks. And in that case, if you're asked to write about the trademarks themselves, you have to make sure that the spelling and the capitalization are correct, because then you'll just get in trouble with the company. And you also have to make sure that you use the correct symbol. The R with the circle, the registered trademark symbol, means that the trademark has been successfully registered with the Patent and Trademark Office. And the TM, which is I think the more common trademark symbol, means that either they're in the process of registering it with the Trademark Office, or they have chosen not to, but it is still a trademarked work. They want that brand or name or slogan or whatever to be seen as trademarked by them. So trademarks and bloggers, in most cases, the same as with freelance writers, it's not infringement to use anything that is trademarked. You can write freely about that kind of stuff. And again, bloggers just have to be careful about not making a profit off of anything. And with bloggers, it can be a little bit trickier because sometimes they're affiliates of certain companies, so they're purposely writing about a company's new products and things like that. And they're generally paid, but they're usually paid by the company, not by customers. So that's why it makes it okay. But there's a very fine line in a distinction there. And then the other aspect of it is there's the rare case of a corporate blogger. Generally, you wouldn't have to worry much about trademark law when it comes to corporate blogging, but there's a small chance that you may have to write about trademarked products or brands, and from an inside perspective inside the company. And in that case, just remember the same things as freelance bloggers or freelance writers, excuse me, in that you have to spell everything and capitalize it correct and use the correct symbol. Trade secrets. A trade secret is a formula, process, ingredient, and so on, with economic value that is known to be secret, such as, a secret ingredient in some kind of sauce at a restaurant or something like that. So trade secrets and freelance writers, there wasn't a lot of relation here. You may be hired by a company that possesses trade secrets, but that's really the only overlap you may have. And if that were the case, it would be highly unlikely that a freelance writer would be asked to write about anything related to the trade secret. And if you do encounter some kind of proprietary information and you do share it, you will be prosecuted. And in the court cases that I was able to find, it is prosecuted to the full extent of the law, which is up to 10 years in prison and $250,000 in fines, and you do not want that. Some freelance writers and bloggers, this is actually, trade secrets and bloggers, this is actually a little bit more important because bloggers have sort of led the charge when it comes to leaks of proprietary information, and very harsh punishments follow that. The one example that I found in my research was a blogger leaked Apple products or information about Apple products that Apple had not yet announced, and Apple tracked him down, figured out who he was, prosecuted him, and he was convicted, and he spent, I think, 7 years in prison and paid $250,000 in fines, which, if you think about it, Apple was trying to, make up for any business they may have lost. I'm pretty sure that they didn't lose any business. Think about all the business that Apple gets. But it's more of the thought that was secret stuff. Someone got the information and released it before you were ready, and no company wants that. So the other aspect of bloggers and trade secrets are anti-employer blogs. And it's important to know that in most court cases, at least in my research, bloggers are not found to fall underneath journalistic protection, mostly because they're not considered anonymous sources, and that's why they can't retain their anonymity in court. So in everything I read, those anti-employer bloggers are found and are punished by the companies that they're bashing or releasing any sort of information about, because it's not supposed to be out there, and they likely signed some kind of contract, so that would be a legal issue with the company, and then they end up getting in quite a bit of trouble for that. Non-disclosure agreements. It's a multi-part agreement between the keeper of proprietary information and anyone who is exposed to it. So how does that relate to freelance writers? You would likely be asked to sign if the company possesses a trade secret, and that would make the freelancer legally bound to keep said secret. You may also be asked to sign if the company is in a very competitive market, just because they won't want any information to be getting out from their company to one of their competitors. So no one wants that sort of information to leave the confines of the company. So that is another reason why you may be asked to sign a non-disclosure agreement as a freelance writer. Non-disclosure agreements and bloggers, very unlikely that this would ever be an issue, probably only if you were writing for a company blog. That's at least all I could find in my research. And again, the company would just want to ensure that nothing secret or proprietary got onto the blog, even if it's an internal blog. So a company blogger may be asked to sign a non-disclosure agreement to prevent that from happening. My last topic is non-competition agreements, which is a contract where an employee promises not to work for a competitor. And there are stipulations that come with that, but that's the general consensus on non-competition agreements. And they only really relate to freelance writers. I couldn't find anything in any of my research that relates non-competition agreements to bloggers, so we're just going to talk solely about freelance writers on this one. So non-competition agreements and freelance writers. You may be asked to sign if the freelancer habitually writes for a single publication, and that's a way for the company that runs the publication to ensure that the freelancer isn't going to release any sort of information or even skills. If that company kind of groomed a writer, you don't want them to go to your competitor and share all your tricks for grooming writers. The thing about this, and it's actually probably one of the more important things that I found in my research, is that a freelance writer should be sure to really understand what is being said in that non-competition agreement, because the agreements restrict employment, and it's essential for a freelance writer to understand what that will mean to their career, because they're limiting. And if you're in a niche market and you sign a non-competition agreement and you can only work for one company and they don't have work for you, you're stuck. You can't find any other freelance work, and that is not good for the livelihood of a freelance writer. So it's actually a very important aspect of intellectual property that freelance writers need to keep in mind. So that's the end of my sort of summary of all of the different kinds of intellectual property and how they relate to freelance writers and bloggers, but I do have a little bit of information that you can take away from all of this research I did. First thing is, utilize your resources. For freelance writers, there are several books that detail relevant legal information for writers, and that includes freelance writers, although most of the books are geared towards writers going through the traditional publishing process. There's still a lot of information about the different kinds of intellectual property, among other kinds of law, that would be very helpful to a freelance writer. And then any blogger could join the Media Bloggers Association. It's generally geared towards journalistic bloggers, but anyone can join it, and they provide any kind of legal counsel if that is something that is needed in any situation. The Media Bloggers Association has actually been winning some battles in court because they have been released journalistic press passes and things like that, and people don't think that they should be, but yet they kind of are journalists. The blogging thing is really taking off. So they're winning a lot of battles right now, and that might be something to keep an eye on. The second thing is to know your responsibilities. The most important thing is you have to really understand what parts of intellectual property are relevant to you, and then keep that in mind when you're writing, when you're blogging. Really, as long as you fully understand and are aware and follow all of the laws, you shouldn't get into any trouble. So that is the very positive takeaway from all of this research I did. At this point, when I was giving a live presentation, I asked for any questions, but since this is a recording, I'm just going to say thank you very much for watching. I hope you took something from this, and I really appreciate an audience.